This is phenomenal news. Following an insane anti-gun decision out of the U.S. Court of Appeals for the Ninth Circuit, the United States Supreme Court and Chief Justice John Roberts announced they will be taking a look at this case. This was announced earlier this morning, and conference will be taking place a couple weeks from now. This is huge news. This case involves a lower court just ignoring the Supreme Court and their standards about what can and can't be regulated under the Second Amendment. We're going to talk about the specific details of this case, why it's so important, and then we're going to talk about how this affects your right to keep and bear arms moving forward. It is a really big deal, though. It's important first, though, that you understand how the constitutionality of firearms regulation works currently. I know this is a bit technical, but if you care about the Second Amendment, I really need you to stick with me. It is just so important that all gun owners are armed with this information. As a chapter president of Turning Point, with my focus being, of course, on the Second Amendment, it is my mission to put the right to keep and bear arms in front of young people as much as possible. This is a right given to us by God and put into the Constitution by our founding fathers. If you want to be part of this movement, please do consider going down below and subscribing. I really appreciate you all. So let's get into it. How does the Supreme Court decide if a specific gun regulation is constitutional or unconstitutional? There are two important things to separate here, and these two things get often confused. The first is the Heller standard. This defines what arms are protected under the Second Amendment. The second is the Bruen test. This determines whether a specific gun regulation is constitutional or unconstitutional. Here's what's interesting though. Both are used in this case, and both are used intentionally incorrectly by the lower court. I am not kidding, this is insane. Okay, so the Heller standard says that the Second Amendment protects any arm in common use for lawful purposes. This means that a total ban on a category of arm that's commonly possessed for lawful purposes is by default and always unconstitutional. Again, by the way, I'm not describing how I think it should be, I'm just describing how the Supreme Court currently operates. So if you don't like it, don't get mad at me. On the other hand, we have the Bruen test. This one's a little bit more complicated, but significantly more important. First, the court must decide if the specific regulation at question implicates the Second Amendment, and if it does, it is presumptively unconstitutional. In other words, anything involving the American people keeping and bearing arms is allowed by default. This is really important to understand. Any keeping and bearing arms is presumptively constitutional. The second step is where it gets a little bit more tricky. The second step asks if the regulation is consistent with America's historical tradition of firearms regulation. Essentially, if the government cannot prove there was a law doing something similar at the time of the founding, and I'll give you a hint, there aren't many, that law is unconstitutional. This test is a massive win for the Second Amendment. You will see people online complaining about it. It is undeniable. This is great for us. Okay, I know that was a little bit technical, but we had to go through that. So now we're gonna move to the case in front of the Supreme Court. It is a really, really big deal. Yeah, so if you remember back a couple of years ago, the communist country of California, who's surprised, passed a so-called large capacity magazine ban. This regulation is insane because it bans any magazine with more than 10 rounds. That's what they call a large capacity magazine, more than 10 rounds. It's unreal. So naturally, all your favorite gun organizations sued to get this ban overturned, right? So here's where something crazy happened. The entire Ninth Circuit, ruling en banc, which means all the judges were sitting, decided that under both standards, this is allowed. So first they ruled that magazines were not a protected arm. Now, if you think about what the definition of an arm is anything that can be used offensively or defensively for self-defense or war. An arm is not the same thing as a gun. If it was, you could ban triggers, you could ban ammo, you could literally destroy the Second Amendment like that. It would be so easy. This is an insane interpretation of the Second Amendment. It's wild, and it doesn't have any historical precedent. The Supreme Court famously ruled that you cannot have a tax on ink, a targeted tax on ink, because ink is part of the First Amendment, protected under the First Amendment. If that's the case, obviously magazines are also protected. Also, just thinking about it logically, a ban on magazines or large capacity magazines is actually a gun ban. Namely, it's a ban on guns that can shoot more than 10 rounds. This makes no sense, but here's the crazier part. I mean, honestly, this part is just offensive to the Supreme Court. They ruled that there was a historical tradition of regulating firearms in this way in America. And they cited, I kid you not, to a founding era gunpowder storage law that prohibited storing gunpowder in certain areas for fire reasons. That's their argument. This makes no sense. And here's the thing, it's not supposed to make sense. They knew the conclusion. They didn't actually do any of the work. They knew the conclusion and worked backwards. It is very, very clear. These anti-gun courts do not care about your right to bear arms, and they will use any excuse. You make a waterclad test, and they will just work backwards and say, hey, that waterclad test? Nah, doesn't count here. It is absolutely ridiculous that some of the most educated people in this country, are able to just look at a Supreme Court case, read it, and completely misunderstand what they're trying to say. Again, of course, I know it is not just a misunderstanding. They are obviously lying, but still, this is insane. Okay, this is a little bit of a rant, but we cannot keep allowing lower courts to do this. Time and time again, specifically with the Second Amendment, but with some of our other core rights, lower courts Somehow, very well educated judges, they read the decision and they manage to completely ignore it. They find, like, let's say either a footnote or, honestly in this case, they just completely misrepresent it entirely and make up their own laws. It is unreal. You have this with the NFA, you have this with a lot of other Second Amendment issues. But this is unjustifiable. This is insane. This is unjustifiable. This is wrong. And they know it. Of course they know it. And we cannot keep allowing them to get away with this. I'm sorry, and I know this is not relevant to the constitutional analysis here, but what are we talking about? This is a joke law. Large capacity magazines, 10 rounds? Are you kidding me? What are we talking about here? The reality is almost all gun violence is one person shooting another. Same way most violence is. Most violence is like me stabbing you, me punching you, me shooting you. It's mostly personal. And yes, of course, there are some instances where, let's say, 30 people are shot, but those are vanishingly rare. Most gun altercations are incredibly small capacity, just literally 1, 2, 4 bullets fired. That's what most violence is. What are we talking about here? Like, this, on the face of it, makes no sense. Why are we even trying to do this? I know, of course, this isn't relevant to the larger, more widespread, like, judicial analysis of this, but it is insane. What they're really trying to do here is just bother law-abiding gun owners. It is so obvious. It is so blatantly obvious. 10 rounds is not like an extreme amount of ammunition. And even if it was, by the way, I'm allowed to have that. And of course, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Obviously, the point of the Second Amendment is to protect against government tyranny. And 10 rounds to do that? Very reasonable. And even if it's not reasonable, I don't care. It is my right to have as many bullets in my gun as I want to. It is my right. Like, what are we talking about here? A magazine is so easy to make, and a criminal can easily take, a 9-bullet magazine and very easily modify it into a fucking 50 magazine. It is so stupid. This is the dumbest thing I have ever heard of, and I do not understand why the anti-gun states are trying to do it, other than obviously to just bother law-abiding gun owners, which of course is the point of all of this. This doesn't even mention the fact that through basically all of American history, we have had large capacity magazines, right? Large capacity, if you want to use their term. This is so nonsense, and it just boggles the mind that people are this stupid. So naturally, the Supreme Court announced that they will be conferencing this case, and I hope they slap them down. There is one problem though. The Supreme Court has already announced 2, which is Hamani and Wolford, 2 cases that they will be hearing and that are Second Amendment related, and I am worried they won't take this one. And I'm particularly worried because the Roberts Court is pretty reluctant to slap down these lower courts. And in my opinion, they need to. They cannot be allowed to keep getting away with this. It is unreal. Now, I know what you have to say, right? Justice delayed is justice denied. And I completely agree. Obviously, I do. I'm a big Second Amendment guy. Now, I've read a lot of experts' opinion on this particular case, and here's what I think will happen. And I think this is actually probably what's reasonable, especially under the Roberts Court. I don't think they'll take it. And I know that's a big red flag, but I don't think they're going to reject it either. I think what will likely happen is they'll either send it back down to the lower courts, or more likely, they're going to push it into next year. I don't love that. I'm going to be completely honest. I don't love that. But luckily on this particular issue, we pretty much know how the Supreme Court's going to rule. There's no way they're going to allow this to stand. Realistically, if they take this case, California will lose. And that will end up being positive. And the fact that it's being conferenced now is a positive development. But in my opinion, I honestly don't think they'll hear it. This is still big news though. This Supreme Court is actively pursuing the Second Amendment cases, not at the rate that I would like, and they're not being aggressive enough, of course. But this might be the next one up after this term. In my perfect world, we would have a mechanism for dealing with these judges because it is just crazy. It is just insane. You and I both know it is just insane. But the only mechanism we currently have is the ability of the Supreme Court to take them. And the reality is the Supreme Court takes 50, 70, 80, somewhere in that range cases per term. And there's a lot of stuff to deal with. My priority is the Second Amendment, but honestly, there's a ton of cases. There's stuff from like mortgage fraud cases to 8th Amendment challenges to 4th Amendment challenges to surveillance stuff. There's just so much for them to take to tariffs, right? That's what's happening today, to tariff cases. And so the reality is they do have a lot on their docket. They do have a lot to look at. And if you're only going to take 50 to 70 to 80 cases a year, right, somewhere in that range, depending on the year, then you're not going to be able to hear 5 to 10 Second Amendment cases every time. And that is a big shame. And unfortunately, that's the situation we find ourselves in. I'd really like to know what you think. Do you think that this will be taken? Do you have any information that suggests that they will take this? And if so, how do you think they'll rule? I'm pretty clear on it. I think if they do take it, we're going to get a massive win on this. And there is the potential for a massive win. I'm not 100% certain. I'd say it's probably 30% they take it and 70% they don't, which I know is not great odds. But I think this case will get taken either this term or the term after. So I think it's very likely we eventually end up with a big win here. I hope you did enjoy the video though. If you did, please make sure to subscribe down below. I'm really trying to grow this channel and I really appreciate all your support. Yeah, if you did enjoy, please do subscribe and I'll see you in the next one.